Thank you. Be seated. First case I'm calling in this afternoon's docket is the innocent owner petition involving the case of People State of Michigan versus Casey Newcomb. This is the petition of Shaki Aku, file
Your Honor,
21.
I'm sorry. The first one is Nolan Alexander.
I grabbed the wrong file. All right, here we go. Then it's Nolan Alexander, People State of Michigan versus Nolan Alexander, file 210195. This is the petition by Larry Alexander. Mr. Alexander, are you here today?
Yes, I am.
All right. Could you please raise your right hand and be sworn? Raise your right hand where I can see it.
Okay.
Do you solemnly swear or affirm testimony you're about to give is the truth, the whole truth, nothing but the truth, so help you God?
Yes, sir.
All right. You can put your hand down now.
Okay.
All right. Sir, you had indicated that you filed this petition and indicated that you did not know that Nolan's license was suspended. How do you know Nolan?
Well, Nolan is my son.
How old is he?
He is 21.
He's 21 years old. Where does he live?
That I couldn't tell you. He has a mailing
don't know?
address, which is my address.
Okay. When's the last time he lived with you?
He hasn't lived with me in probably about a year.
And up until then, he lived with you until about a year ago?
Year and a half, yeah. But he,
And
go ahead.
go ahead.
He would be in and out. He occasionally he would stay other places. He did live in Midland at an apartment place for a while, but he hasn't lived there in quite some time.
Okay. How was it that he had your vehicle?
Him and someone, I don't know, there was another gentleman with him, needed a truck to move some things, so I allowed them to use my truck, which is the one that supposedly was doing spinning a parking lot, if my memory serves me right.
Okay. Well, he had a driving license suspended. Looks like in 2016 when he rode without a cycle endorsement in Saginaw. He'd have been living with you at that time.
Yeah, 2016. Yeah, he was. Yeah, because he would have been living with me then. I'm trying to think. I've been out of town for the last few years, and I've been back a few times to visit, and I've been back here for about a year now. And
So you're saying you had no idea his license was suspended?
No, sir.
Now that you know that his license could be suspended, are you planning on letting him borrow your truck or vehicles?
No, sir. That is my truck that I use to pull my tool trailer from job to job to run my home repair business. I'm a sole proprietor of, and no, he does not use any of my vehicles anymore.
All right. Well, you were under oath and you had made a statement that you did not know that his license was suspended. He did live with you, but not for a while, and you lived out of state. I'll believe that that is true. And I'm going to order that the vehicle does not have to be immobilized or forfeited. Ms. Tidwell, you're working on this petition?
Yes, Your Honor.
Okay. Can you work with Mr. Alexander about getting, do you have a metal license plate on the vehicle, sir, or you need to get one for it?
That vehicle has not been renewed. There is a license plate on it that expired on my birthday in May, and it has not been renewed yet.
Okay, so they didn't take the license plate.
No.
Okay. Ms. Tidwell, I think you just need to process the paperwork then. Would that be correct?
Yes, Your Honor. That's correct.
Okay. How long do you think it'll take you to process it and get it into the system?
I'll have it submitted today.
All right. Sir, you may want to wait a day or two to make sure Secretary of State gets its information from us, but it will be submitted and sent to them today.
Okay.
All right. We'll be adjourned on your case. Thank you.
Thank you.
Calling case of the People State of Michigan versus Daniel Collins, file 20-1105 SD. Mr. Collins, come on up and have a seat at the table, please. Ms. Branson, good afternoon.
Good afternoon, Your Honor.
Go ahead and have a seat, sir. You can pick any of the chairs. Yeah, that's a good one as any. Is the computer screen on? Okay, there's a button on the front lower right-hand side. If you push it, you'll see some of the same things and makes it a little bit easier to see, I think. It's on now? Yes, sir. Okay. All right. Ms. Branson, you filed this newest petition. This is a 4th technical violation.
That's correct, Your Honor, and there should be an amended one that includes the 5th technical violation as well.
All right, so let me show you this, Ms. Branson, and make sure I got the right one. I think I have the right one now. And if I've got the right one, please let me know. It should be on your screen right about now.
Yes, that is correct.
Okay. All right, Mr. Collins, the allegation is that your violation was that you failed to attend counseling as directed. That's one. And then another violation, which is the 5th one, submitted positive alcohol test on SoberLink on June 6th. Either one of those would be at least a 4th violation. 4th violation under the new law has different parameters than the first 2 or 3. First 2 or 3, there was a change in the law that took place in April, and it took away discretions of the judge to be able to just pull somebody off probation and put them right in jail. You had to follow a step process. And so the punishment after the 1 is maximum penalty of up to 5 days. Punishment after 2 is 10, after 3 is 15, but we need to keep you on probation according to the statute. After 4th, we don't. So if you're guilty of that violation, you could receive up to the maximum. I'm not saying that's what you'll get, but you could get up to the maximum penalty of what you were initially sentenced to. It looks like an impaired driving, so up to 93 days, minus any of the days you've already spent in jail. You could be removed from probation. We could extend probation, but it doesn't look good. It's been 4 or 5 times since you've had some issues. Now, you have a right to challenge the allegations. You could hire a lawyer, or I could appoint one for you. You could see, hear, and question witnesses against you, subpoena witnesses, even testify if you wanted to, but you wouldn't have to. Burden of proof at these hearings, when someone's on probation, probation is kind of an act of grace. And so the burden of proof is a lot lower. So the proof balance is not the beyond a reasonable doubt that you have a criminal or even a contempt. It's a preponderance. So is it a little more true than not true? That's the standard that I'd have to weigh. So if I weighed it on a scale, it'd be like a 51-49. I'd have to believe it's true. Also, rules of evidence aren't followed, which means not a whole lot, except we can admit hearsay documents. So when you have another case, you'd have to have somebody testify. There may not be any testimony. It may just be a piece of paper that says you didn't show up. Now, I'd still have to believe that it was true and make sure that it's a valid source. You couldn't just have somebody who just really doesn't like you send in a piece of paper and say you didn't do this. But that's the burden of proof, and the rules of evidence don't apply. So at this point in time, do you understand what the allegations are?
Yes, sir.
Okay. You can take your mask down to speak with me if you're comfortable doing that. And could you repeat that?
I have all my shots.
Okay, good. So, and I think the courts will follow suit pretty soon. We just haven't heard from the Supreme Courts that we can't. I even wear a mask through the building, and I've got both of my shots too. But since we're more than 6 feet apart, we should be okay today. Okay. Did you understand the allegations, sir?
Yes, sir.
Katrina, can you hear him okay?
If he could speak up a little bit, that would be great.
That red microphone is the microphone. You can slide a little bit closer. You have come a soft voice.
Okay.
Did you understand the potential consequences if you were found to be in violation?
Yes, sir.
You understand your right to hearing and your right to a lawyer to help you at that hearing?
Yes, sir.
How do you wish to proceed? Do you wish to have a hearing regarding this, or do you wish to admit guilt?
Admit guilt, sir.
Okay. Why don't you stand up and have you raise your right hand? Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Okay, go ahead and have a seat. You understood your right to a hearing and your right to a lawyer, and you decided to waive those rights. Is that true?
Yes, sir.
Has anyone promised you anything to get you to plead to this?
No, sir.
Has anyone threatened you to get you to do this?
No, sir.
Are you right now under the influence of any medicine, drugs, or alcohol that's confusing you?
No, sir.
Knowing that, how do you plead to violating terms of your probation by failing to attend counseling and testing positive on SoberLink? Do you plead guilty, not guilty, or stand mute?
Guilty.
Do you acknowledge that you're on probation to the 75th District Court?
Yes, sir.
One of the terms of probation is that you're not supposed to drink. Is that true?
Yes, sir.
And another one is you should be going to counseling. Is that true?
Yes, sir.
And you did fail to go to counseling as you were directed. Is that true?
Yes, sir.
And you tested positive on the SoberLink on June 6th because you actually drank sometime before June 6th.
Yes, sir.
All right. I find that the plea has been made knowingly, understandingly, voluntarily, and accurately will enter in records of the court as a violation of probation. Ms. Tidwell was on the last hearing. Ms. Branson, could you please give me an update and your recommendations for Mr. Collins? And then Mr. Collins, I'll have you get a chance to say as well.
Yes, thank you, Your Honor. Mr. Collins has been on probation for about 6 of his 12 months at this point. This is his second show cause and encompasses his 4th and 5th technical violations on probation. To give you some positive information, he did complete Impact Weekend as directed back in April, and he did recently sign up for new counseling at Great Lakes Psychological Group. However, he did have the 3-month lapse in counseling, which is what the violation was for. Obviously, some not good things since he's here. He did have the positive SoberLink tests on June 6th. I gave him an opportunity to go get an ETG test since he originally denied those allegations. Sounds like he's admitting to them today. He's also behind in his payments to the court. And most recently, I just got another positive SoberLink test from yesterday morning. At this point, I feel he's had a lot of opportunities to try to succeed on probation and just hasn't been able to do so. Being that these are the 4th and 5th technical violations, I don't feel that probation is appropriate any longer. I would be recommending 10 days in jail and an unsatisfactory discharge from probation. Also, I want to make sure that he does return the SoberLink equipment to avoid any further additional charges on his account.
Did you happen to bring the SoberLink equipment with you?
It's in my car.
Are you back to work?
Yes, sir.
Malley Construction still?
No, I'm working by myself.
Are you doing your own construction work?
Yep. I'm in the middle of a bathroom right now.
Doing a remodel for somebody?
Yes. In Saginaw, I'm working at their home. I'm staying pretty busy. It is hit and miss with COVID, so it is hard to find jobs, but I am somewhat staying busy.
When are you going to be done with that remodel job?
Probably by Monday.
By Monday?
Yes. I can say that this probation has helped. You know, my quality of life has gone up, seeing that I'm not drinking like I used to. I know that I made mistakes, but still, you know, like my relationship with my children and with my girlfriend, it has gotten better. So.
Well, that's good. Are
There's
you on
positive.
probation anywhere else down Saginaw, or are you all done with those?
I'm all done.
So this remodel that you're doing, was it because it's just old and they just wanted something new, or did somebody else mess it up and you had to fix it?
No, it's just they want a new bathroom.
Did they pick all the stuff out, the colors and the tiles and everything, or do you do it?
They usually pick it out. I go to the store with them.
So what if you picked up the wrong stuff, took it back and installed it?
And I installed the wrong product material. Well, they
Yeah.
wouldn't be very happy, would they?
And you probably have to take it back out.
Yes, sir.
They probably would understand, but not be happy.
Correct.
What if you went back, didn't check with them and grabbed more product, less, but grabbed the wrong mirror and put that up?
I'd be upset.
Then what if you then grabbed the wrong toilet and installed it? What would happen then?
I would have to return it and put a new toilet in.
And if you did it the 4th time or the 5th time, they probably wouldn't want you on the job.
Yeah, I'd get fired.
I have some concerns that you maybe have some underlying issues that you haven't addressed yet. The only reason I say that, I'm not a psychologist. I'm not. But I see you served our country honorably, your honorable discharge. I see a lot of young men, and I say young man because I am older than you are. So young is into now the 30s and heading into 40s for me, who have seen a lot of things a lot of us haven't, and they don't deal with it. And then eventually they try to drown it out with alcohol. You had not much, not really no criminal history until 2019. And then the wheels fell off. And I know you went through the divorce, and I know you had a lot of issues, But I gotta think that a big part of that was the drinking, and there's a very high probability that you're dealing with some things or not dealing with some things that you need to. Problem is, you kind of have to want that more than we do. I mean, by the time you've not installed the wrong thing the fourth or fifth time, there's not a whole lot more that we can do. And, you know, probation is primarily designed to try to get the person to look at life, make some changes, and make things better so they don't get back into the system. And in a really short period of time, he had a whole lot of criminal charges. It just seems out of character. So as an armchair quarterback of some mental health issues, I don't know if you were going down to the VA. You probably should, or get some kind of counseling dealing with it. I have no idea what you saw or didn't. Maybe you didn't. Maybe you just decided you want to be drunk. But most of the time, the people that reach your age, about 35, and have kids who can watch and see what their dad does, they usually don't get involved. You got a 4, 6, and 8-year-old, and they're probably turning 5, 7, and 9 pretty soon.
Yes, sir.
They watch every single thing you do. They know when you're in trouble and when you're not in trouble, and you're probably not the same guy when you drink. The issue is we run out of circumstances. So there's going to be consequences. The recommendation is for 10 days in jail. I feel bad for the people that you just started the job with and didn't finish. I suspect, Ms. Branson, you said, have you had contact with him or circumstances where he's not had contact with you?
Not recently, Your Honor. Recently, he's been pretty good about staying in contact with me and giving me updates on where he's at with counseling.
All right. Well, I have up to 93 days. I don't think probably 93 days is going to make any difference more than just a couple. Has he got any other jail credit or just the one?
Just the 1 day is all I saw, Your Honor.
All right. Well, here's what I'm going to do. I'm going to trust that you still have honor and that you will follow what you said to do if I give you an opportunity not to hose over your customers.
Yes, sir.
So I'm going to remove your probation. I'm going to sentence you to jail for 14 days. But you can report. You said you'd be done next Monday?
Yes.
That's the 28th?
Yes, sir. I believe
And you're pretty confident on that.
I will make it done.
All right. I want you to show up to Midland County Jail next Tuesday
Yes, sir.
by noon.
Yes, sir.
You'll spend 14 days in jail because I'm giving you the opportunity, instead of having the deputy take you now, to finish your job. So it's going to cost you an extra 4 days in jail. If you do not show up by noon, then it's going to be 93 days for contempt.
Yes,
And
sir.
I won't bat an eye because I'm trying to make you keep your good name in the building trades. I'm also giving you this 2 weeks because the 4th of July holiday is a big drinking holiday. And right now, alcohol is not your friend. It's not been your friend. You've had domestic violence. A person who was sworn to protect the Constitution and the people of this country turns his hand against people that he loves. It is out of control for you. And so I want you in a safe place over the 4th of July holiday weekend. And I want you to take those 2 weeks and think about what it would be like not seeing your kids, not seeing your girlfriend, not having a business. And you got time between now and Katrina, is that the 29th?
28th, Your Honor,
Tuesday?
Monday, the 28th,
No, it's Tuesday the 29th.
Tuesday, the 29th.
Yeah. He's going to have that was his best guess, and things always don't go as they plan. So it'll be Tuesday, 29th. You're going to need to have, one thing I'm going to ask you to do is go out your car and get your sober link. Bring it back in. Mr. Alexander, you be able to assist him in that or not? Oh, okay. So you can bring it back in so that you don't get charged $750 or whatever
Yes,
for
sir.
that. You're off. If you get drunk between now and then, they pick you up, all bets are off.
Yes, sir.
And I'm going to take a look at that and say that's dishonorable. And then that would be contempt of court, and I'll use all 93 days.
Yes, sir.
You no longer have to report. You don't have to go to probation. You don't have to meet with anybody. You just need to go to your car, come back in with the unit.
Yes, sir.
Other than that, should he go over, Mike, to the criminal window or probation window to get the order? Because they won't let you in jail unless you have the order with you.
Yes, sir.
If you come back, bring it over to the unit to the probation window, go to the criminal window, pick up your paperwork. Don't forget the paperwork because they will not allow you into jail. I've had a lot of people call, oddly enough, panic because they can't get into jail. I hope you turn it around. You're of the age where most people do. Crime is typically a young man's game, usually done by 35. So you're a little delayed in the length of time, but your kids are a little younger too than most people. Most of the time it's when their kids hit early teens that they don't want their son or daughter to follow in the exact same shoes as them. They start caring more about their kids. I need you to start thinking about them.
Yes, sir.
All right. We'll be adjourned on this case. Thank you. Thank you, Deputy.
Your Honor, I have two iPhones. I'm not sure who is who.
Well, Mr. Garsky's name, so it's not him. Let's find out. Who do we have on the iPhone? Sir with a blue shirt, and it looks like in a shop that's got a heater over your left shoulder, hanging up high.
Can you hear me?
I can. Can you tell me your name?
Kyle Boone.
Thank you, Mr. Boone. Then let's find out who. I would say you two look awful a lot alike. The other iPhone, you're in a car, looks like you're in a passenger seat, and you got a gray shirt on. But you also have a beard.
Yeah.
And you also have a nice head.
Yes, sir.
Just like your counterpart. Can you tell me your name?
Christopher Rowe.
All right. We got Mr. Kyle Boone and Christopher Rowe. Mr. Garsky, you have Mr. Rowe. Is that correct?
Correct, Your Honor.
Okay. It's shocking how much you two look alike, Mr. Boone and Mr. Rowe, to me at least. But thought maybe you were relatives of some sort. But let's go ahead and start with Mr. Rowe's case because I have Mr. Garsky here. This is the case of the People State of Michigan versus Christopher Orlando Rowe, file 21-0479SD. Counsel, please identify yourself for the record.
Marcus Garsky, Your Honor, with and on behalf of Mr. Rowe, is appearing today via Zoom.
Mr. Garsky, did you get a copy of the allegation?
We did, Your Honor, but there was two positive blows.
Have you had an opportunity to talk about it with your client?
We did, Judge. He would admit that those were positive blows. They did up his testing. And then I don't know if there would be any recommended sanction. We just asked to continue with the increased testing. He's been clean since the last blow. There's been no problem since then.
All right. I see Ms. Tidwell. Good afternoon, Ms. Tidwell. Are you the pretrial service coordinator for this case?
Yes, Your Honor.
Presume that Mr. Rowe is going to admit that he has violated his bond with these two tests. What were your recommendations?
Your Honor, there's been some other times where there's alcohol been detected below the cutoff level. It appears that drinking starts at night and then he tests positive in the morning, or he's already positive by the time he's testing for the last test of the day. I know that he travels quite a bit for work, which is the reason we use SoberLink. And initially I did only have him testing a couple times per day based on what he told me his pattern of consumption was. After the first test, I did bump it up to 4 times per day. We still had another positive alcohol. I think Scram may be the better option here to monitor it. It just appears that there's some drinking going around the testing. He does travel out of state for work about 50% of the time. However, I think that with house arrest service, so long as he's notifying them, he'll be able to take the base station needed for downloads and such with him when he's traveling, and it'll allow us to monitor alcohol more closely. He did complete an assessment at JNA. I don't have that back yet, but I'm hoping that will provide some additional insight here. If alcohol consumption is ongoing, perhaps a higher level of services will be needed. I do know that he'll be out of the state through the 4th of July weekend, so I'd ask that he be placed on Scram when he returns to the state.
All right. Mr. Garsky, may I ask your client about where he's at and just some
Yes,
general
Judge.
questions?
And then just so the court knows, he did complete his eval from JNA. That was dated 6/9. They recommended 8 individual counseling courses with 1 scheduled to begin via Zoom this week. So we just wanted to let the court know that has taken place as well.
Okay. My inclination. So Mr. Rowe, what state are you in today?
I'm currently in Michigan. I'm traveling the next 2 hours. I'm going to Denver, Colorado. Then I'll be in Utah, and then I'll be in Texas, and then coming back to Michigan the 4th of July weekend. By that Sunday is what it's looking like. Yes, sir. Flying.
Okay, I was going to say that's a lot of travel in a short period of time.
Yeah, I'm flying.
When do you leave for Denver?
Today, in 2 hours.
Today? Okay.
Yeah.
All right. I think the recommendation that I'm gonna presume that you're gonna admit that you tested positive on the sober mic.
Yes.
True?
Yes, sir.
Okay. Rather than revoke your bond, which is a possibility, if we can't keep control of you, we revoke your bond, then you sit in a Midley County jail, and that's a last place option. I think having that scram device that lets you travel wherever you need to go, you don't have to worry about blowing or testing; it just stays on you. But it costs more. But I think if that makes sense to me, especially with where you're going and what you're doing. It doesn't make sense to have to find some place to test, to drop a urine test, and increasing the number of testing is a problem. So don't make your attorney's job any harder than what it needs to be. Follow his advice. He gives good advice. You're paying him big money to do it, so you should follow what he tells you to do. I'm going to modify that. So I want you to contact Ms. Tidwell after the 4th of July. When you're back in town, we'll coordinate that for the scram tether. Then
Sure.
if you're blowing the scram tether, you're really, I mean, that's like kind of our last resort. The Midland County Jail, very, very rarely do people drink. I'm not so naive to think that they may try to make their own hooch at some point in time, but it's really, really rare. So we know that people don't mostly get in trouble there. So let's not push that envelope so you can keep working. So, Mr. Garski, I don't know when our next court date is. I didn't pull his case up, but
Judge, there's a pre-trial tomorrow morning. And at this point, there's still not an offer, but we're in discussions. So we would just be asking the court to set it for another pre-trial.
Okay. And he could do it by Zoom pretty much anywhere where he's at, right? If they made an offer. Okay. We are, just for your notification, we are in July starting to do jury trials. So we've got the clearance. Our positivity rate is down sufficiently, and we're going to be scheduling them. So sometimes people will use that. Not saying you do, but just saying if that's something that, thinking that you got more time, once we start clearing out the docket, those trials will be going starting July 8th, I believe. All right, we'll be adjourned then on this time. I'm just going to make the determination of the plea that he did plead to it. So sometime after the 4th of July, please get in contact with Ms. Tidwell to schedule for the device, the scram tether. All right,
sir.
All right. Anything else, Mr. Garski, need to place on the record before we leave?
Not for today, Judge.
Okay, we're all set. You will need to check in with your lawyer tomorrow, Mr. Rowe, in case they have an offer. You'll be someplace in Denver, Colorado, I suspect at that time. But they have, I hear tell they have cell phone towers there too, so that you can be in contact. All right, thank you. Be safe.
Thank you, Honor.
Thank you. All right, Mr. Boone, calling case of the People State of Michigan versus Kyle Ryan Boone, file 20-1209FY. Mr. Boone, good afternoon, sir.
How's it going?
I'm doing well, thank you. Ms. Hoffman, I see you popped in. I presume that Mr. Boone is on your caseload. Is that correct?
Correct, Judge.
This is a show cause. So let me pull up. Sir, I'm going to share with you a copy of the document so that you can see where I'm getting the information from. Let me know when it pops up. It's probably a little small for your screen, but I want to make sure you see the same.
I got it. I got it, sir.
Okay. So it says here that you tested positive for alcohol on May 28th and admitted to consuming alcohol on or about that date. It's first technical violation. You have a right to have a hearing regarding that. This isn't the hearing. This is me just informing you what that is. So first technical violation, because of the change in the law by the legislature in April, instead of me just saying, well, probation didn't work and put you in jail for up to 93 days, or here, if you pled to the second offense, up to a year, depending on what the plea was, it is only up to 5 days. Doesn't mean that's what you'll get. That just means that's the most that could happen. Or we could increase testing. Yeah. We could change the type of testing that takes place. There could be those sanctions. Plus, we could order you to do some community service, or I could order you to pay some fines or additional costs. Kind of depends on what the recommendation is. Kind of depends on how you did on bond. A lot of it depends on your actions as to what the penalty will be. You have a right to challenge the allegation. You could hire a lawyer, or I could appoint one for you. You could see here and question the witnesses against you, subpoena witnesses. You could even testify if you wanted to, but you wouldn't have to. But the rules of evidence don't apply to these types of hearings, and the burden of proof is preponderance, meaning is it more likely true than not? So, do you understand the allegations that are against you?
Yes, sir.
Do you understand your right to a hearing and your right to a lawyer to assist you at the hearing?
Yes, sir.
Do you understand the maximum penalty that could be imposed against you if I found you to be in violation?
Yes, sir.
All right. Well, now it's up to you. What do you wish to do? You wish to admit to the violation, or do you wish to have a hearing?
I admit to it.
Okay. Why don't you raise your right hand where I can see it? Do you solemnly swear or affirm testimony you're about to give is the truth, whole truth, nothing but the truth, so help you God?
Yes.
You can put your hand down now. Has anyone promised you anything to get you to plead to this when you really do not want to? Has
No.
anyone threatened you in any way? Are you
No.
under the influence of any medicine, drugs, or alcohol that's confusing you?
No.
Did you understand your right to a hearing and your right to a lawyer to assist you with the hearing?
Yes.
And you're deciding on your own to waive that right. Is that true?
Yes.
Okay. How do you plead to violating your probation then? Guilty, not guilty, or stand mute?
Guilty.
Do you agree with me that you're on probation to the 75th District Court? The underlying charges were for alcohol, drinking and driving in an open and intox?
Yes.
One of the terms of probation is that you're not supposed to consume alcohol. True?
Correct.
And in May 28th, you tested positive for alcohol. Is that true?
Correct.
And that's probably because you drank before you tested. Not directly before, but sometime before you tested, you were drinking alcohol.
Yes.
All right. I find that the plea has been made knowingly, understandingly, voluntarily, and accurately will enter in as a violation of probation. So what were you up to? What was the trigger? Why would you risk this?
Well, I just lost 3 family members that were really close to me.
Sorry
And
to hear that.
my sister was here from another state. Thank you. My sister was here from another state because of my grandma, who I was living with. She actually just passed away May 17th. So my sister was going back to Arizona, and we kind of had like a little dinner, and I drank a beer with my food, my meat.
Did you tell?
And that's why I tested.
So just checking to see if you're being honest with yourself and everybody around you. Did you share that information with your therapist that you drank?
After I did.
But before he wrote his letter supporting you?
No. Once I find the day I found out about this, I actually had to talk to my therapist that day, and I talked to him about it.
You kind of put him in an awkward
And
spot.
he asked me if he wanted.
He wrote a letter.
Yes, kind of. I didn't. Go ahead.
He wrote a letter, glowing report on June 7th. But on June 7th, you had already been drinking, but you didn't tell him. And so then, I mean, he risks his credibility with the courts if he writes this report and then find out that you're drinking. I could look at it and go, well, this therapist doesn't know what they're doing. Or I could say, Mr. Boone kind of put his therapist in an odd spot because he wasn't being honest with him or telling him that he drank. Because I doubt he would have wrote that letter. He may have waited. I mean, he eventually may have because you guys got a good connection. But you got to think about the consequences, not just for
Right.
you, but for other people. Because if I didn't know better, I mean, you seem like you're taking responsibility for it, and I appreciate that. But you potentially caused your counselor to lose face in front of a judge. So it'd be hard for me to take a look at anything that he says and go, well, that guy knows what he's doing. Did you ever think about that?
No, to be honest, no. I understand what you're saying, though.
Yeah, you lose credibility one time, and it could be gone. Well, let me check with Ms. Hoffman and see what her recommendations are. Ms. Hoffman, good afternoon again.
Good afternoon, Your Honor.
Can you give me an update on Mr. Boone? He did get a glowing report from his counselor, although I don't think he probably would have tempered it a little bit had he known about the drinking offense. What can you tell me about him, and what's your recommendation for the violation?
Certainly, Your Honor. Mr. Boone is on an 18-month term for operating while intoxicated, second offense, as well as open intox. His halfway point would be November 22nd for review for early discharge. He has been testing since he was on bond, which began back in November. He did have a positive test for cocaine in December. That was dealt with and considered at the time of sentencing. He did serve 5 days in jail at the point of sentencing as well. He submitted negative testing since then until this May 28th test. A good thing is that he was honest with me about it. He didn't try to deny the fact that he was drinking. I wasn't aware of the circumstances surrounding it regarding the deaths in his family. But either way, he did admit that he consumed alcohol. And then, Your Honor, the support letter, I'm honestly not sure if that came after Kyle discussed the drinking event with his therapist. I took it as maybe he had that discussion and his therapist wrote that in support of him, knowing that he was facing the court and he didn't want him to lose his job. That's how I took it. Your Honor, I think took it a different way in listening to you today. I can't be certain on that, but I had kind of tailored my recommendation around that as well, that he did address it with his counselor, which tells me that he's trying to work through the mistake that he made and his lapse in judgment there. He is working full-time still. Kyle reports to me as directed, and he's always respectful. His fines are paid in full as well. My concern, Judge, obviously, is that this is an operating while intoxicated, not first offense, but second offense in an an open intox charge as well. And this isn't the first test. However, this is the first technical violation of probation. So it's the first time that he's messed up on probation so far. He's doing everything else in stride as far as I can tell. And so at this point, I wouldn't be recommending any jail, but I would recommend a $50 fine and increased testing for a period of time. Certainly, if there are any more violations in the future, I'd be leaning more toward a jail recommendation.
All right. Well, I reread that note as you were talking to me. It does look like maybe Mr. Cotterman did know about that. I wish he would have put it in his notes, because it does make me question whether or not he is going to be. I want someone to be an advocate for their clients, but I want truth. And had he put in there, hey, I know he drank, that would have been a little bit more clear. Mr. Boone, you have to realize that you are putting other people in awkward positions if you make these decisions. And Hoffman's right. The next time you get a drunk driving, it's a felony. And I don't know what you do for a living, but felonies close a lot of doors to a lot of people for a lot of things. And you need to really get a handle. Yeah, I get that. And I appreciate your honesty. I mean, you told her about it, you acknowledged it, you took responsibility. But at some point in time, you know, this next one, it could be up to 10 days in jail. And I'll determine that the fine, meaning money, and increasing testing didn't work, because it makes no sense for me to keep using the same tools to try to change your behavior. Does that make sense?
I understand.
All right. So I'm going to follow the recommendations. It'll be a $50 fine, which you're going to have to pay. And then you're going to get in touch with him, talk about the increase in frequency of testing?
Yes, Judge. Actually, he can just continue calling. I'll contact Sacred Heart in Flint, where he's testing, and have them increase accordingly. He's scheduled for a report date this Thursday, the 24th. All
right, Mr. Boone. Let's get back on that straight path. You had a long stretch where you did really well. Let's finish this out. And with the new laws, if you don't flub up in your last 3 months, you have an opportunity of still finishing probation at the halfway point, which is November 22nd. If that doesn't motivate you, I don't know what will.
It does. And believe me, I'm trying, and I apologize to anybody and everybody that, that this caused a problem for.
Best thing you can do is not drink. That'll be the best thing you can do to thank people. All right. We're all set. Thank you.
Thank you.
So I see a name of Zechariah, and I'm trying to match it up with a case. So if you could please unmute yourself and tell me which case that we're here on.
The Newcomb Casey Don case.
Ah, the innocent owner petition. Here we go.
Yeah,
All right. Thank you very much.
you're welcome, Judge.
And I see Zechariah, but are you Sakahai Ku?
Yes, I changed my name when I became citizens of this country.
Oh, congratulations. When did you become a citizen?
Thank you.
When did you become a citizen?
Back in early 2000.
Early 2000. Well, you've been a citizen for a long time. Must somehow still have your car titled under your previous name.
Yes, I did change it as Secretary of State, but they never, every year they send me the renewal. It still has my own name on it.
Okay. Is the last name still Kueq? Okay. All right. This is the case of the People's State of Michigan versus Casey Newcomb. It's an innocent owner petition. This is file 210131ST. I have Zechariah Q, who is here and is alleged to be the owner. Ms. Q,
Your Honor,
you submitted. Yes.
I'm sorry, there's a lot of background noise that I'm hearing, and I'm not sure if it's a volume issue on his part or.
We're getting a lot of feedback, Mr. Q.
Okay, yeah, I'm getting that. We're getting that done right now. I have some guys working downstairs, so I have them down for a little bit.
All right, there we go. So you didn't give any reasons why your car shouldn't be immobilized.
Well, this is what happened, Your Honor. I sold my car to my neighbor over a year ago. And
so it's not your car.
So it's not my car anymore, Your Honor. I sold it to my neighbor a year ago, and I signed over the title and all that. And whether he changed it over, or in this case, he never changed it over. He just took he took the car from me, and then I didn't know what he did with the car. And then I just got this letter in the mail, and I'm like, Barry, what'd you do with the car? So I am so as clueless to what is going on here as I just don't know.
So do you know Casey Newcomb?
I have no idea who that is. Okay,
and you don't own the car anymore, although the title still comes back to you.
Right.
Okay, I'm gonna order that the car be immobilized. That way, if someone is driving it, it will be have to be impounded. But you do have some risk if someone gets in a crash with that car, they can sue the driver and the owner. And right now, you're the owner. So you're going to want to try to get that cleared up with the Secretary of State and your neighbor. It sounds like whatever your neighbor did with the car is not helpful to you, because obviously you had to take time out of your day to be part of this hearing. And you could be sued if someone gets hurt or killed with that car because you're still the owner. So you should be very motivated. It's not going to be any impact on you. This does nothing to your record. It just, if someone's driving that car and it gets pulled over, they'll run the car and lean, and then the car will have to be impounded. But you should have a long talk with your neighbor about what did he do with the car, so you can get that car not titled in your name anymore. Okay? You have to unmute him again, Katrina. Hang on. Zechariah, we can't hear you because you're muted, so you'll have to unmute yourself. We were getting feedback.
Okay, I'm sorry. I sold the car to my neighbor, and he said he gave it away to charity. So yes, I will follow up with him to see if he still have the title and get that taken care of.
Yes, because it's still titled in your name. So this doesn't do anything for you criminally, so it's not like you're in trouble. It's just that we had to send notice to the owner, and you're still, it's bad news that you're still the owner, because if somebody gets that car and crashes and kills them, the insurance companies and other people will fine you just like we did.
Okay.
Okay. All right. We're all set. Tina, I'm going to order that the car be immobilized.
Thank you.
All right. Thank you, Ms. Q.
Thank you very much, Judge.
Have a good day. Mr. Alexander, which case are you here on? Oh, he's next.
He's here in person because I added some additional.
Your Honor, we cannot hear Mr. Alexander at all.
Oh, you can take your mask down. You had some additional ones?
It's two additional violations that I amended the show cause with today, hoping to serve him in person.
All right, well, I'll call the case because we're 20 minutes beyond his time slot.
Your Honor, I do have people out in the lobby. If you can give me one moment, I will see if it's
Sure, we're
him.
looking for Jarrell Ojeda. Did you see Mr. Ojeda in the?
There was nobody out there, but I'll go out.
Oh, that's right, she's gonna.
Jarrell Ojeda. Your Honor, he is not in the courthouse lobby.
All right. So calling the case of the people, state of Michigan versus Jarrell Ojeda, file 20-0937 SD. Mr. Alexander is here from the probation department. Mr. Alexander, you had indicated that there are some additional allegations that you wanted to augment the record with.
Yes, Your Honor. The original violation was for him not signing up for the random testing program as I directed him to. And today I added additional violations for failing to report on June 17th as directed, and also failing to attend counseling or provide documentation of counseling as directed.
When's the last time you had contact with him?
Your Honor, we had a show cause on May 24th. I spoke to him on May 25th by phone. Then I left him a voicemail on June 1st. June 2nd, I tried calling again, and the voicemail was full. I emailed him on May 25th, June 4th, and June 7th, and have not heard from him since May 25th.
So did you file the new probation violation? Because I do see one that's in the system dated June 21st.
Yes, that was the one, the two additional violations.
Okay, obviously he wouldn't have had notice of that, but he would have had
Correct.
notice. I see one from June 7th that said that it's supposed to be in person and the defendant failed to sign up for random testing and drug and alcohol use directed by his probation agent. It'd be a second technical probation violation. All right, the defendant has not appeared. Is there anyone in the Zoom meeting room? Katrina, is there anyone in the Zoom waiting room? You're muted.
No, Your Honor.
All right. There's no one in the courtroom, and we've hailed the halls. He's not appeared. Bench warrant was issued for his arrest. This will be, because of the second violation, this is going to be a immediate bench warrant. Will be adjourned on this case.
Thank you, Your Honor.
Thank you.